Welcome, everyone. I'm Alison Poulsen, and I'm here with my colleague George Seisme-Durant to coordinate this podcast discussion on the draft National Planning Framework 4 with Brodies Supremes, Neil Collar, Karen Hamilton and Elaine Farquharson-Black, who form a formidable planning front row, it must be said, and like Clarkson, Hammond and May brought to Top Gear, their success is not just based on knowledge and experience, but fortunately a passion for their subject and their sense of humour. So on that note, let's kick off.
I hate to ask Alison who is who before we start the discussion.
that can be some of the questions.
Yes, no comments, please, in the comment box on that particular topic.
So, as we all know, there's been a lot of chat on the content of NPF4. We've blogged about it. You can read our blogs on our website. We'll continue to blog about it. But Neil, it might be useful, given that we've been asked lots of questions, to kick off this podcast with the legal context of the NPF.
Yeah, thanks, Alison. It did feel that that was something that the audience would find useful. As you said, there's been a lot of chat around whether it's the green energy policies or the housing policies, but the overall legal context is very important, and that's not just us as lawyers saying that. The starting point inevitably is the Section 25 mantra that we all know and love, in the sense of applications being determined in accordance with the provisions of the development plan unless material considerations indicate otherwise. The reason why NPF4 is so significant is, for the first time, it's going to be part of the development plan, and it will sit alongside the local development plan, the LDP, and come on to that in a few minutes. So it gives it that legal status. It is still policy, and again, we're going to talk about interpretation of policy and what the law has to say about that. But what the law says is the NPF will form part of that starting point in the consenting process. It might then be useful just to touch on what is the status in consenting of the current draft, because that's something that impacts on consenting applications decision making at the moment. And I was quite interested, was looking at some recent Section 36 decisions on the bigger wind farms. And what the minister said is that they were giving limited weight to the draft NPF because it doesn't reduce the current policy support for the proposed development. So that's the particular context of green energy. And they're saying, and I paraphrase, it doesn't really make a great deal of difference because it doesn't reduce the policy support. Depending on your viewpoint, it might increase it. There's obviously calls to significantly increase it beyond what the draft says, but they're saying we're noting it in passing, really, but we're not regarding it as significant. And certainly that's consistent with the legal approach, the legal principle to all draft policies, that while they're going through consultation, they tend to be given limited weight because nobody knows what the outcome of the consultation is going to be. So you can't start saying, well, we're going to pre-decide the outcome of the consultation and give it strong weight or overruling weight or something like that. The next thing I was going to just touch on quickly, because it was something that arose in a conversation we were having with clients, was what's going to happen to the Scottish Planning Policy document, the SPP. It sounds like this podcast is going to be well, it's not going to be the bonfire of the acronyms. What's the opposite of having a bonfire of acronyms? I suppose it's a cascade of acronyms that we're chucking out. So apologies, those of you who maybe aren't just quite so used to planning, if we dive into too many acronyms too quickly. If we throw out something and you're wondering what it is, then put it in the Q&A and we'll translate for you. So yeah, the SPP, it will vanish because the NPF is intended to replace it. And those of you who are familiar with the SPP will have already seen that there are some policies that have just been transposed pretty much directly into the NPF. So the expectation is that it will vanish and we'll all just look at the NPF. I touched on the definition, the legal definition of the development plan, and the fact that it includes the NPF and LDPs. And that was something else I just wanted to spend a minute on talking through the legal context. How do the two bits of the development plan fit together, and how's it all going to work? Well, I say how's it all going to work, I wish we had the answer to that. A lot of it is very much going to be wait and see. But in terms of the principles of it all, LDPs, the current LDPs, quite often repeated policies from the SPP. And that's something that's a bit familiar to us as lawyers, that lawyers don't like necessarily using somebody else's wording. And much as we were taught at university, you don't just change someone's wording because you don't like it. You should only really change it if there's a material difference. There's an element of an LDPs that some local authorities have the wording that they like, which you look at and you think it's different. I'm not sure if it makes a difference if there's a material difference. The point here is because the policies in the NPF will be part of the development plan, same status in law as the LDPs, that takes away the necessity to actually do that duplication. And the Scottish Government do hope that that means we'll get shorter LDPs. As I say, there might be a bit of a temptation for local authorities still to do their own version. But there's always that question mark about whether it's really different enough for it to be worthwhile. There's always the issue, the question mark of, well, what if the two plans say different things? Does one get preferred? And what the Act says is, if there's an incompatibility between the NPF and the LDP, whichever is later in date prevails. So the starting point is, once this NPF is approved, which we're told will probably be the summer, but that's not cast in tablets of stone, that will supersede the current LDPs to the extent that there's an incompatibility. The interesting thing is there is no legal requirement for new LDPs to be consistent with the NPF. So that's a bit of a difference, because previously, when we had the strategic development plans, there was a legal requirement for consistency there. And you can see there's a logic. You know, what's the point in having a situation where the law allows plans to be inconsistent and incompatible and giving you that problem? So in theory, once the new NPF is in place, a disconform LDP could be adopted. So a local authority could try and go its own way. But the likelihood in practice is that the procedure of the draft LDP being examined by a reporter, examined in any objections that have been put forward, that would prevent the incompatibility emerging, because it seems unlikely that a reporter would allow an incompatible LTP to go through unless there was a very good planning reason. And if there was a very good planning reason, then of course we would all support that happening. So that was a few initial thoughts around the legal context, and moving that sort of legal context discussion onward a bit. I'll pass it over to Karen, who's going to talk a bit about what the law says in terms of how you actually interpret the NPF.
Thanks, Neil. There's certainly been a lot of questions about interpretation being raised in consultation responses so far, and I think partly that's arising due to the structure of the draft that's been employed within the NPF. But the starting point, at least on interpretation, is a familiar one to us, and that the legal position is that you have to read the document as a whole. So whichever particular element of the development plan, you're reading the development plan as a whole. So that's familiar to us, really, regardless of this being a new document. I think the particular challenge with the draft NPF, which as we have it, is that we've got these 4 sections of the document. So we've got the spatial strategy, then we've got the section on national developments, and we've got the National Planning Policy Handbook, and then the section at the end of the document on delivery. And these different sections are not necessarily serving the same purpose. So I think that potentially adds to the challenge of reading the document as a whole. So for example, the spatial strategy, we might reasonably assume is going to be most relevant to the preparation of LDPs, but potentially it should still be taken into account when deciding planning applications. And so there's a question as to how that should be done and how that will work its way through. I think if we focus on the policies themselves, and again, reading the document as a whole, you've got that typical problem, and I mean, this isn't a new thing, of perhaps certain strong policy statements potentially being diluted by other topic-specific policies, which may seem to cut across them or involve different tests or inconsistent language. So you might see that, for example, in terms of the green energy policy, or where we have the very strong statement on climate change, where we've got the statement within the draft that significant weight has to be accorded. When you look at the small print of the green energy policy itself, we can see that the bar is potentially set quite low for refusals on certain types of development. So, for example, talking about adverse impact as a possible bar for refusal on solar development. So it's that potential inconsistency between policies when you try to look at the document as a whole. Of course, that's what we're all used to kind of grappling with in terms of the daily job, and typically lawyers and planning consultants will be tending to focus on the bits that particularly suit their arguments, but that's that tends to be the challenge when you're approaching a document like this. We've also got, in terms of the sustainable policies, at the beginning of the handbook being badged as universal policies. So the intention there is that those will apply in all cases, but when you look again at the small print of those policies, some of the wording suggests otherwise. And again, that's something that has been raised in consultation responses already. I expect that's something that may come out through amendments of the draft to come. I don't think there's any special significance in terms of weight that's intended to attract to those policies, except in the case of the climate emergency policy, where a specific direction has been given on that front. And that's the only place that we see that in the whole of the draft wording at the moment, that significant weight has to be given to the climate emergency policy. So I think, you know, going back and comparing it with the SPP is easy to say perhaps that SPP had a clearer structure, we had policy principles, and we had the delivery. And so, you know, we could perhaps criticise the draft as not having quite the same sharpness as the previous SPP in that respect. But I think being fair, this is obviously a much more complex document. It's trying to do a much broader range of things. So inevitably it's going to look and feel different. And, you know, I think there's always that tendency just for us all to, you know, have the sharp intake of breath when it's something new that we're going to have to grapple with. I think finally, maybe in terms of key objectives, there's a clear statement as to the primary guiding principles for all plans and decisions in the draft, and that relates to climate change and nature recovery. And I think that's something that a lot of people will support. But potentially some of the key objectives of planning reform have got diluted by the detail. And I think the big one that jumps out there is in terms of housing. I know it's certainly dear to Elaine's heart, in that perhaps that strong message as to the urgency of the need for delivery there isn't coming through as we might have expected to see. So over to you then, Elaine. I'm glad you've been able to join us.
I know the internet connection was rubbish, so it's quite nice to join the party if a bit late. And kind of all your sort of questions and queries there. I listened to the Local Government Housing and Planning Committee questioning of the Chief Planner, Fiona Simpson, and Andy Kinnear, who's kind of head of transforming planning. It's available on the Scottish Government website. It's an hour and a half, so you have to kind of settle down with a cup of tea. And the committee has kind of started to ask a number of those questions that you were sort of kind of raising there, and I thought it might be quite interesting to kind of touch on them. So they asked questions about the concerns about the lack of clarity, you know, in the draft, and that it maybe contradicts itself in places. Now, we're used to that, you know, it is, you look at it in everything in the round and you weigh them up. And it was interesting because the first answer that was given was that in NPF4, they're trying to balance clarity and certainty with flexibility for local circumstances. So trying not to touch, you know, to kind of pin down the detail, to try to allow flexibility for local authorities. And the indication was that the framework recognises that rural places, for example, are quite diverse. They've got different circumstances, different challenges. And they're looking at the spatial strategies they touched on at the beginning of the plan as giving kind of that local colour as to how they should interpret the kind of the wider national policies in the local area. So they gave the example, one of the questions was about balancing onshore wind and tourism. If you're trying to do both, how do they deal with that? And I was saying you need to look at it from a local point of view, and that the local place plans might have a role to play in that. What does the community see as their primary concern? Is it onshore wind or is it tourism, which is most important? On the clarity and contradictions, the answer was that this is just a draft, and they're keen to kind of hear from stakeholders, and you know, a lot of people are writing in it to that extent. I thought there was an interesting question for us lawyers about the use of should and must, and you find that as you're kind of going through the document, and the Law Society have picked that up in their reps, the planning thing, and what the answer was that must is only used where it's a statutory requirement, and should is being used where it's policy or practice. So it's a recommendation. It's still an expectation that you would do it, but what they're saying is we can't say you must support this development because the local authority needs to have the discretion, but they're kind of encouraging you to do that. So that's kind of an interesting one. There was also a question about the lack of definitions, and you know, we've discussed this and we've got that in one of our blogs. You know, what does community well-being mean? And again, it was a kind of an interesting answer was that the NPF will be a statutory document, so the text needs to be fixed. So they've been careful not to over-define the references, and would rather include the working definitions in the guidance. So something that's going to have statutory weight, but we're not going to define it, and we're going to put that definition in another document, that rings a lot of alarm bells for me.
Yes, I think it's all well and good until you actually expect a developer to deliver what it is that you're wanting.
Well, and we've got the concern, of course, if all that's in the guidance, and going back to the section 25 point, it's not part of the development plan. The guidance isn't part of the development plan. And going back to the Supreme Court decision in Elsick, they made the point that failure to take into account a material consideration is unlawful, but you don't need to follow it. As long as you've taken it into account, you don't need to follow the guidance. That doesn't make it unlawful. So the local authority can take into account the guidance, but doesn't need to follow it. I actually quite like the guidance. The guidance reads a little bit more like Scottish planning policy, so I felt quite at home in it. So I did actually quite like it. But those, to me, it's interesting that the committee has already picked up on some of these points that kind of you made and other people have made. So.
So it's maybe a good time to move on and say a little bit about one of the other sections of the NPF, which is the national developments, which obviously something that we're all not coming across every day of the week. But it's perhaps interesting to compare the new draft with the NPF3 just to see how things have moved on. And it's fair to say that it's a case of evolution and not revolution, which I think would be as we would expect here. A lot of repeat projects, as again might be expected. Indeed, some of the projects on the list have been there, I think, since the first iteration of the NPF, such as high-speed rail. But that's, of course, the nature of the beast when it's these big infrastructure, big ticket projects that are going to take such a length of time to come to fruition, certainly in some cases. The projects themselves are quite a mixed bag. On the one hand, we've got some quite clearly defined site-specific projects. There are Scotland-wide projects for specified classes of development without any particular spatial element to them. So they could really be qualifying as national developments if they fit the identified class, regardless of where they might be planned in the country. And then we've also got what I'm referring to as sort of large scale master plan type sites under the banner of distinctive places. So this is where we've got the likes of Dundee Waterfront, which again is a repeat project. We've got Clyde Mission in Glasgow, the waterfront in Edinburgh as well. And so there are 5 falling into that category. That's not a new approach, as I say. We've had national developments of that type in before. Dundee Waterfront, Ravenscraig was a previous one, but there's certainly more proposals falling into that category than was the case with NPF3. So whether that just indicates a kind of a bit of a different emphasis, perhaps moving forward. But it's an interesting list in any event.
Just before you go on, Karen, we had a question about on national developments. It says there are 259 suggestions for national development. What does being a national development status or acquiring that statement actually achieve?
What it achieves? Well, it's a good question, because when you think about it from a procedural point of view, ironically, the national development status actually brings more in the way of procedural hurdles to jump over than would otherwise be the case in terms of obviously PAC and pre-hearings, etc. But I think the real benefit for national developments is probably less to do with the planning decisions themselves at the end of the day and how they're ultimately received, but more to do with building the case for the project or the particular location in the case of these distinctive places, and more about building momentum. So if you think about a project like Glasgow Metro, for example, which would be part of the mass transit projects that have been identified, that national designation ultimately will give weight to the business case for the project, and really will seen as solidifying the political commitment to the project, and that will also help with related processes such as compulsory purchase, etc. Should should that be necessary in due course, which of course might be quite likely with a number of these projects given their nature. So it's really a sort of wider benefit rather than looking at it from the kind of more narrow planning perspective.
And then kind of looking slightly further forward, NPF4 is, we obviously don't get the full picture. It's not just about the national policy framework. Is there more to come, and have you got any thoughts on that?
Yeah, well, I've kind of mentioned the guidance, George, already, and we've also got now published the draft LDP regs to try, which kind of sit along in all the public consultation, and they're all running to the 31st of March. And if you read, the ministers have worked to the principle that they're trying to keep the regulations to as minimum as necessary. I'm not sure if they're trying to keep the lawyers out of it, but the regulations actually are fairly limited, and when you read it, they're superseding the 2008 regs, so pretty much they just kind of repeat the 2008 regs but remove references to things like strategic development plans because we don't have them. So there's not a lot of meat kind of in the regulations. What they do confirm is that a proposed local development plan, which was being published before the relevant date, will continue to be governed by the processes under the 2008 regs. And if the regs say the relevant date is the date on which the regs come into force, and we obviously don't know that yet, but if you look at the supporting papers that have come out, Part B, it refers to the transitional guidance, and they're aiming for June 2022 being the kind of cutoff. So if the LDP has already been published, the proposed plan by June, it'll carry on under the previous. Interestingly, one of the things that we've been looking at is the evidence report and the gate check for LDPs. That's going to be a critical part of how they kind of come forward. And I sat on the working group for that with the Scottish Government. And it's been interesting to see that a lot of the group's recommendations have been followed through, in the guidance. There's a template for evidence reports, so that there's going to be, kind of some conformity and sort of uniformity across all the authorities. And effectively, this will be the baseline data from which the proposed plan will then emerge, and it's got to be deliverable, place-based, people-focused kind of LDP. There's going to be no site-specific proposals. You don't include site-specific proposals in the evidence report, and there's no detailed policies. And the role of the gate check is to confirm that the sufficiency of the evidence base. Do you need that number of houses? Is that what the evidence kind of supports? So I read it all. You do wonder whether it's a main issues report by another name, calling it an evidence report, but actually is it not what we've all been looking at as a main issues report? These are all the things that you can expect to be covered, kind of in the LDP.
I think that's going to be such an important part. Getting that working correctly is going to be such an important part of the new LD process, really, delivering as is wanted. I think another sort of interesting aspect of the wider picture is, what you might view as being the continued expansion of the role of planning in what we see coming out of the draft NPF. So something that you'd mentioned already, Elaine, from what the discussion that you were looking at last night on, for example, community wealth building, which features in one of the universal policies. And you do wonder if there's just a need for us to sort of tread carefully with that. So with something like community wealth building, we might all agree there are laudable aims there, but potentially we're looking at a new form of planning gain coming in so far as developer requirements are concerned in terms of the sort of development management aspects of those. I think, going back to your point about, well, there's no definition, but there's lots of literature certainly about community wealth building and some familiar concepts around progressive procurement, social enterprises, talk of community wish lists, etc. And all of that might sound might sound generally beneficial, but are these really matters for developers to be addressing at the end of the day? It does remind me in some ways about some of the discussions around community benefit in the sphere of renewables, where ultimately you know, developers may make certain contributions, but they're not regarded as being material considerations, and so they're not something that should be taken into account in the planning process. So it'll be interesting to see how that pans out in due course. But I mean, we've mentioned ELSIC on the discussion once already today, and you know that's potentially where you can end up when these sorts of things are taken too far. But as we know, the planning system is generally seen as a vehicle to cure a lot of social ills. And yet again, I think we're seeing that popping up in the draft, albeit I'm sure with, you know, the best of intentions.
Although with the kind of place principle that it's encouraging, you know, we're seeing more perhaps focus on pulling everything together and all the different, you know, aspects of a development and looking beyond just the development. And you know, have we got the health in place? Have we got the education in place? And perhaps trying to make it more of a kind of corporate approach to development and not just kind of the planning aspect.
I think so, and I think you can see that sort of working in a probably more from a development planning perspective, but when it comes to contributions or elements being included in you know, in every major development application, you know, that then has to take a very concrete form. And I think the question being, well, what's that going to mean for developers? So potentially quite onerous.
And as it's just gone past, let's go to some questions. We've had a couple about the kind of the consultation process, and we've mentioned that it's ongoing. And so what do you think will happen in the consultation / parliamentary procedure? Do you reckon the NPF will be different? And how do you kind of square public consultation comments with the parliamentary consideration that's going on in parallel? So perhaps Neil on that one.
Yeah, it's an interesting one because unlike the planning bill that we all suffered through, I think there is no other way of putting it, this isn't a bill. There isn't such a rigid and understood process. Well, I must admit, it's been described to me a few times what's likely to happen with the committees taking evidence and Scottish Government producing modifications, but I have to admit I'm still a bit fuzzy about how it'll actually work in practice. But I think it is worth remembering that the planning bill process, part of the reason why it was so painful was there were so many modifications, there was so much lobbying. It seems likely there will be just as much lobbying on the draft NPF because a lot of the issues that people were concerned about are common. The nature of the instrument, as it were, is different. Draft NPF, its policy, the bill was obviously going to be law, but the issues and the concerns and whatnot are the same. I think the perception is that because it's not a bill process, it might be more difficult to actually procure particularly major changes. You know, Elaine was telling us a few minutes ago about her bedtime listening last night of the committee and the chief planner saying very much in listening mode. So there is obviously still scope for modifications, but one has to wonder whether whole-scale changes are likely, given that the aspiration is still to get this NPF approved in the summer. So it's a bit of a wait and see. Just picking up on a couple of specific points that came through the questions. And sorry if you were about to ask me that. Someone was saying, will the weight of the draft in consenting decisions increase as we go through this consultation process. I don't think the consultation process is going to work that way. It feels as though it's going to be evolving, and it will be difficult to identify a point, a milestone at which, oh, we could say something would have more weight. So we can see how that goes. And another question was making the point, and I suppose it's worth repeating, that we've got this slightly strange scenario where the draft is subject to public consultation until 31st March, but at the same time, the parliamentary committees are calling for evidence, and we've already passed one of those deadlines. So it's a very disjointed process that way, and it's again hard to get a grasp on how that actually works in practice.
Just Neil, if I could kind of come in there, it actually came up in the questions that, and one of the committee members, made the point, we can't amend the draft plan, kind of in this process, and therefore was asking, the chief planner how they're discussing it with developers, and Fiona said it is a draft policy. We are keen to hear the views from the stakeholders. We're going to be meeting. They've got a number of online, kind of events. I would hope that we are going to see some changes, to the final draft, or else you do have to question, why we've been doing the public consultation, and it is extensive. And they were asked in the committee how much, consultation have you done, and what are you going to carry on doing it. So I would hope that we will see some changes.
Around perhaps time for one more quick question. Probably best for Elaine, but in terms of housing type and tenure, is there scope at this stage to promote a new type of housing to meet housing needs, particularly in the context of ageing population?
Yeah, no, that's it. I know that has been raised. I know, there is a press for Homes for Scotland to make housing a national development, because you'll remember back at the beginning, part of this started with the changes and the reforms to the legislation was the need for more housing and the infrastructure to go with it, and therefore that kind of national recognition that housing, is important and that we need it. They obviously haven't gone there, although there is housing included in some of the national developments that Karen, kind of referenced. Yeah, and I know there's a push to try to say that housing with care. I work with the Scottish Housing with Care Task Force, and they've made representations and are going to appear before the committee. The suggestion that either you need to make clear that there's a specific allocation of housing required for older people, which is set out in the primary legislation. You've got to deal with it, or should it actually not be class 9? Should it be class 8? Should we be looking at a new use class for it? So yeah, that is certainly something that has come up and should therefore be being considered as part of it.
Perhaps one more then. That was nice and quick. So in the national development sections, perhaps one for Karen, a lot's written in the third person, and only one section, being the Northeast, saying what it actually expects within LDP. And so as a statutory document, do you reckon this goes far enough? This is sufficient in terms of kind of not being quite so specific?
I think there's been quite a lot of commentary about, I suppose, delivery at the end of the day in terms of both national developments and the wider scope of the NPF itself, and obviously there is an action plan and programme to come. That's been a feature of the NPF system so far, but I think people are very keen, to see how that's going to look. But I think in terms of LDPs and what's to be required of them more generally, I think that's coming from not just the national development section, but the kind of wider plan making policies within the NPF. And as Neil was saying at the beginning, in terms of what we're going to see in the LDPs to come, there's obviously a timing issue there. And while we would expect the first sort of suite of LDPs to follow, to very much be following the NPF, over time it may well be that we'll end up with discrepancies between those documents depending on the timing. But obviously that's very much what will be looked at in examination of LDPs as they come forward, and the extent to which they are complying with the kind of wider policy framework. I wouldn't personally get so hung up with issues about the sort of third person language and just how directive some of the language seems, kind of taking a sort of common sense approach towards the reading of it, and going back to Lean's discussion earlier about should and must and all that sort of thing. But I think the important thing is perhaps less about the sort of way in which some of that language is presented, but is the meaning sufficiently clear overall?
That's probably all the time for questions. I guess one final comment from each of you on what's a positive, or one positive point from NPF. Couple of minutes whiz through.
So this was the challenge that we set for ourselves in finishing on a positive note. Well, if I jump in first while my mic is on, perhaps just very briefly from me, I suppose I would highlight the infrastructure first policy that is contained within the draft, which, I mean, certainly is not unexpected. Obviously, it would have been a major shock had we not seen that coming forward in the draft, but it's good to see that policy on the page now. And I think a sense that things are certainly travelling in the right direction with infrastructure. But I think successful implementation of all of that is really going to tie back into some of the things that Elaine was saying around the process with the new LDPs, evidence reports, gate checks, particularly on the infrastructure side of things. It's going to, for the infrastructure first approach to work, it's all going to be about having a suitable and robust evidence base there at the beginning of the process. But there's a whole lot more work to be done in this area, particularly on the funding side. I know that lots of people are still raising questions about, infrastructure levy and where are we with that. I mean, work's certainly continuing on that front, but there are a lot of moving parts that are all going to have to come together for us to see the infrastructure first approach working, successfully further down the line.
I'll then come in to kind of, because it picks up obviously, as you sort of said there on the evidence check. I suppose the bit that I was pleased to see is finally, both in the NPF and the guidance, the fact that you can't just keep rolling forward sites that have been allocated in LDPs for however long and just keep doing it. They have to be reassessed, and they're going to be assessed in accordance with the appraisal methodology for new sites. So they're kind of back and assess, is it coming forward? Because far too many times you're an LDP and there's a site's been in for 20 and it's never coming forward, and it's never coming forward. So that's probably my
We're losing Elaine there. Do you want to jump in, Neil, with your top pick?
Well, I'm slightly worried because Alison introduced this Top Gear style that at the end Alison's going to get us to have a robust debate about whose choice was best or worst. My favourite bit of the NPF is policy 2 on the climate emergency, just in the sense that it's a great starting point for planners to be in the driving seat. Yes, there are possibly weaknesses in the policy in the sense that it's very, very general and it doesn't really tell you what to do. But just the mere fact that it's there does give planners in the planning system that oomph to get on with it.
Well, on that note, I want to thank all of the speakers. Thank you for ending on such a positive note. And we'll take it forward on my rugby front row comment, and that is we've been passed the ball and we've got to do something with it by the 31st of March. So that's been a useful roundup of the context now in which we can all see the NPF, and good luck everyone with the responses. So thank you for today's podcast. We're going to have our next podcast in February 24th, and we look forward to seeing you all then. Thank you very much. Bye-bye.